Patriotism is not natural, but has to be taught or somehow acquired. And the question was then, and I suppose still is, how was this new patriotism to be taught or somehow acquired by later generations of citizens?
On the one hand, he loved the country, thought people had to be encouraged to love it for reasons that had been stated by Walter's great hero, Abraham Lincoln, especially in a free country. It can't be taken for granted that people will simply love the country and do the things that are needed to protect it.
This was not simply the rah-rah patriotism of a war hero, which he was.
Walter was a veteran of World War II. He had served from the absolute beginning in the Navy. He had seen action. I used to like to tell my children he had taken North Africa single-handedly when they were still young enough to believe that. And so he had a very powerful sense of what the country had been through. And Walter in particular had a sort of odyssey after World War II. But eventually they pitched up in Taos, New Mexico, where a writers' artist colony had been founded.
He was going to be the, great American novelist, but then eventually he burned the manuscript. I just decided that wasn't him and wound up going to the University of Chicago. And someone told him, you have to take a course with this fellow, Leo Strauss. And Walter said, I'll do it next semester. And finally he did.
He was very greatly influenced by Leo Strauss, and Leo Strauss said, we should go back and read Aristotle. We should go back and read old books because we can still learn things from old books. And it's not enough to say, I don't completely agree. All right, you don't completely agree. What is it you think is right? And if you start by saying, well, no one is right, if there is no right, you're just going to go through life chortling and chuckling and being frivolous and silly. And that isn't the life Walter Berns was going to lead.
Walter believed that true patriotism for an American includes an appreciation of self-criticism.
We are not expected to love our country simply because it is our country. Love can be blind, and love of country, like love of wife or husband or lover, can be blind too. But ours is not supposed to be a blind patriotism.
But he always insisted that our criticism of the Constitution be fully informed, that criticism had to be based upon a full understanding. And it was that fuller understanding that he spent a good deal of his life in reviving.
Walter Berns was one of a very small group of scholars who made the founding relevant again and really fundamental to our understanding of ourselves. We take it for granted now that, well, of course, if you study America, you have to read the Federalist Papers and you have to think about the Constitution and the Constitutional Convention and John Marshall, not just the latest Supreme Court cases, and you have to read Lincoln. That was not the case when Walter Berns began writing on these topics in the 1950s and into the 1960s. And he and a small group of friends and colleagues of his really revived the study of the founders, showed why you couldn't understand America without understanding the founders.
I think part of what happened to Walter and to a lot of other people is that the left changed out from under them and came to really reject the vision of the Constitution. To be a partisan of the Constitution, which is, if Walter was any kind of partisan, I think that was his party, by late in his life meant that he was a conservative by default. But I don't think he was a conservative in the way that the conservative movement understands that term. I can see how Walter would be uncomfortable with the term, and a lot of people of his generation were. But the fact is, he and they transformed conservatism in a way that made it more like them. I think what today's young conservatives mean by thinking of Walter as a conservative is purely a compliment. It means that they see themselves shaped by his teachings.
Walter Berns was at AEI when I came here in 1986, and he was here for all of my tenure as president, up until his 90th birthday. He was in the office every day, right up to the end. He was the complete intellectual and the archetype of what AEI has always tried to promote and insinuate into larger political debate.
When Lincoln was a young man, he gave a speech about the Founding Fathers in which he called them a forest of giant oaks. I thought Walter very much represented that image. These were people in the founding whom Lincoln felt had greater challenges than his own generation. Walter Berns was one of the giant oaks Lincoln spoke about, and he's left an extraordinary legacy for those of us who are still here at AEI. His scholarship and his great strengths as a colleague and friend to many here.
Hi, everybody. That video gets a little bit more terrifying every year. I'm Yuval Levin of the American Enterprise Institute. Welcome. It's my great pleasure to welcome you to AEI's annual Walter Berns Constitution Day lecture, to be delivered this year by our colleague and friend, the great Jack Goldsmith. These lectures are a long-standing annual tradition at AEI. Constitution Day has been marked by some talk or commemoration in one way or another for many decades at AEI, but since 2011, we've marked it with a formal lecture named for our, as you see, much admired colleague, Walter Berns. Walter, who many of us here had the privilege to know and to learn from, was a scholar of the Constitution and of the American political tradition whose work shed light on an enormous range of subjects, from religious liberty and freedom of speech to presidential selection, civics education, the thought of Abraham Lincoln and John Locke, and much more. He brought to all of that work a sharp mind, a sharp pen, a profound love of country. He was a model for all of us. Walter passed away 10 years ago at the age of 95. He's greatly missed by all of us at AEI, and it's really an honor for us to have his wife Irene here with us tonight. Thank you, Irene, for being here. This year, to mark the 10th anniversary of his passing, we've collected the Berns lectures delivered so far into a book, which you can find right here on the table. Please help yourself to one. You can order them online, too. And one striking thing about seeing these lectures collected in this way is the range of the subjects that these talks have taken up, which is, I think, a nice reflection of the extraordinary breadth of Walter's own interests and knowledge. I like to think, I hope, he would have been very proud to be associated with them. And I know that he would have been very proud to be associated with our speaker tonight, Jack Goldsmith. Jack is, of course, first and foremost to us, a non-resident senior fellow here at AEI. He's also a law professor at Harvard. He's a seasoned and experienced public servant. He served as Assistant Attorney General in charge of the Office of Legal Counsel at DOJ in the Bush administration, and as a lawyer in the Defense Department and elsewhere. He is more than that. Jack is, in this moment, an absolutely essential public voice on the Constitution and the law. He is a clear-eyed observer of the courts and the administrative state. He's someone who doesn't panic easily, but also doesn't whistle past graveyards, tries to see things as they really are in a complicated time. Through his public writing and through the Substack that he runs jointly with Bob Bauer now, he's made himself really nothing short of a vital public teacher on the law. And we are all, in one way or another, his very grateful students these days. Jack's going to speak tonight on presidential greatness and the fragility of judicial supremacy. After his talk, he'll be in conversation with Adam White, the Lawrence Silberman Chair in Constitutional Governance here at AEI. And with no further ado, let me turn things over to Jack.
Thank you, Yuval, for that kind introduction. And thanks to the American Enterprise Institute more generally, and especially to my colleagues in the Department of Social, Cultural, and Constitutional Studies, from whom I learned so much. It is an honor to be giving the Walter Berns Lecture in celebration of Constitution Day, which I believe is tomorrow. I teach tomorrow, so I think that's why we scheduled it today. I never, unfortunately, knew Professor Berns, but I do admire his work, and in particular, and this was alluded to in the film, his emphasis on citizen virtues and common good duties as the precondition for successful constitutional government. I wonder what he would make of American civic virtue today and what he would prescribe to fix it. I expect it would be something akin to Yuval's terrific book, American Covenant, where one sees clearly the traces of Professor Berns' work and influence. As best I can tell, Walter Berns did not address the topics I will cover tonight, presidential departmentalism and judicial supremacy, and I'll explain in a moment what I mean by those terms, at least not directly. He was articulate in denouncing government by judiciary, but he said very little, actually surprisingly little, about the presidency as an institution. He did, of course, write very eloquently about Abraham Lincoln, whom he revered, though he said nothing about Lincoln's famous departmentalism, which I will discuss in a moment. I hope he would agree with what I have to say. So speaking of Lincoln, we live in an age of extreme anxiety about presidential power. I think that's an understatement. Consider a few comments about the president. Our rogue president has crossed an historic line, and so has the Republic. Apparently, America now has its first emperor. The president is acting as a monarch. The president thinks he's Caesar. The president has cemented his legacy of lawlessness. I am sad watching our Constitution shredded. These comments, as you might have guessed, do not come from 2025 or at any time during the Trump era. These comments could have been made in many periods in American history, as I'm going to discuss. Can anyone guess when they were made? Do you know? 61? No. Oh, 1861? Could have been 1861. No, they were made 11 years ago by Pat Buchanan, Jeff Sessions, Ted Cruz, Mike Huckabee, John Bonner, and Sean Hannity in response to President Obama's announcement that he would defer the deportation of the parents of children who are U.S. citizens as legal residents. And the point of these examples, and many of the others I'm going to be using and discussing, is that rhetoric about presidential excess is nothing new. George Washington was widely denounced, was widely denounced and widely pilloried for his monarchism. Yet the rhetoric points to a paradox about the American presidency that I want to explore this afternoon. The paradox is that every single recognized great or eminent president, and practically all of the so-called near-great presidents, pushed the limits of executive authority so aggressively that each was denounced in his day as undermining the Constitution. Consider three related claims by prominent presidential scholars. Political scientist Richard Pius. Presidents who go down in the history books as great are those who reach for power, who assert their authority to the limit. Political scientist and historian Clinton Rossiter. If a president, this is my favorite, if a president is not widely and persistently accused in his own time of subverting the Constitution, he may as well forget about being judged a truly eminent man by future generations. It's true. Historian Arthur Schlesinger Jr. The greats and near greats, the great and near great presidents, all took risks in pursuit of their ideals. They all provoked intense controversy. They all, except Washington, divided the nation before reuniting it on a new level of national understanding. These claims express what I take to be a deep truth about American constitutional history. Very aggressive presidential leadership, verging on what was viewed at the time as persistent unconstitutionality, is a mark of a great president. That should be a paradox to us. In this lecture, I'm going to try to cast light on the paradox, which I see as a truth, to tie it to the debate about presidential departmentalism versus judicial supremacy, which again, I'll explain in a moment, and then to reflect on some current events and how they relate to current events. I should note up front, I have many debts in this talk. I've learned from a lot of people. I've been reading a lot about judicial supremacy and departmentalism lately, and the two people I've learned most from, I just want to emphasize, are my late colleague Dick Fallon and Yale law professor Keith Whittington, whose work did influence my thinking, but who are of course not responsible for what I say. So what explains the paradox of great presidents pushing constitutional limits? First, a word on great presidents. I regret, when I was writing this lecture, which was after I had given the title, I regret using the phrase great presidents, because it's such a normatively loaded term, what counts as a great president, and I fear that could be distracting to the points I want to make. I used the phrase because I wanted to talk about George Washington, Thomas Jefferson, Andrew Jackson, Abraham Lincoln, and Franklin D. Roosevelt. And I don't think it's controversial to say that these are great presidents and among our greatest. The game of presidential greatness got going, I think, in 1949 when Arthur Schlesinger Sr. wrote an essay in Life magazine in which he consulted progressive historians who listed the great presidents, and those were the top 5. His son, Arthur Schlesinger Jr., repeated the poll in 1962 and 1996 in the New York Times and got similar results. Conservatives would complain about these polls because they were basically polling progressive historians, and these presidents were in various ways progressive, or certainly they fulfilled what the kind of Democrat progressive ideal of the heroic presidency. And obviously presidential greatness depends on one's conception of the presidency, and there are different views of the presidency. There was a poll of Tea Party libertarians in 2012 who chose Harding as the greatest president and Lincoln as the worst president. And that's okay, and I expect some people in the room may think that might be true. But still, I think my 5 are safe, and I'm going to rely here on a Wall Street Journal Federalist Society poll in 2005 of, as they put it, an ideologically balanced group of 130 professors of history, law, political science, and economics. And who came out on top? Washington, Lincoln, FDR, Jefferson, and I'm afraid Jackson was number 10. In any event, I'm focusing on these presidents, and here's what I mean by presidential greatness. I mean basically successful presidential leadership in crisis and otherwise. Great presidents possess or are possessed by a vision of an ideal America, said Arthur Schlesinger Jr. The most successful presidents, in my view, anticipated the needs and opportunities of the nation that others did not see, understood the inadequacies of inherited institutions, and led the nation to a new and better place in ways that defied prevailing constitutional understandings and provoked resistance and controversy. Obviously, Washington was writing on a blank slate, but he imposed his independent constitutional vision on the Constitution as well, as I'll discuss. So what did Pius, Rossiter, and Schlesinger have in mind when they described the 5 presidents as one's accused of subverting the Constitution and provoking strong controversy? Here is a thumbnail sketch. George Washington, the Neutrality Proclamation and the Jay Treaty debates, all that they implied for a super broad unilateral presidential foreign affairs power, the First National Bank, perhaps the way he suppressed the Whiskey Rebellion, and other things, but those are the main ones. Thomas Jefferson, wiping out federal courts populated by Federalist judges in clear violation of Article 3, the Louisiana Purchase, executive privilege in the Burr trial, and perhaps the Embargo Act. Andrew Jackson, his uses of the vetoes as political tools, which was a constitutional innovation, his veto of the Second Bank when he disagreed with the Supreme Court's interpretation, the spoils system, and many controversies in connection with Indian removal, among others. Abraham Lincoln, too numerous even for a partial list, but includes unilateral suspension of habeas corpus, arrest without due process, aggressive use of military commissions, expanding the military and imposing a Southern blockade without congressional authorization, the Emancipation Proclamation, and more. And again, FDR, too numerous to list, but basically all of the extraordinary powers, and I could sit here for hours talking about them, exercised in connection with the New Deal and the extraordinary domestic and foreign powers exercised before and during World War II. So many well-known examples. So why did these great presidents push constitutional limits? The short answer, and maybe the obvious answer, is because they're expected to, because they have incentives to, and because Article 2 and other constitutional provisions permit it, or at least can be read, sometimes controversially, to permit it. The Constitution, as we all know, creates a powerful independent executive branch, invests in the president the executive power, a fatefully undefined term, elaborated only through a few non-exhaustive grants of power in the rest of Article 2. And from the very beginning, from the beginning of the Washington administration, this vagueness of the office, the unstructured nature of the office, and the conferral of all of the executive power on the president, combined with other elements of constitutional structure to encourage presidential initiative, what Hamilton and Federalist 30 called energy in the executive. Contrast the office of the president, these are obvious points, with Congress, which is a collective and hierarchical institution that can typically only act through bicameralism, and courts, which are reactive and in the end only have the power of words. Schlesinger, writing of the early republic, said, correctly in my view, experience demonstrated rather quickly that the system of checks and balances would not work at all unless one of the three branches took the initiative, and that it worked best in response to vigorous presidential leadership. Such leadership was necessary to overcome the tendency towards inertia. What this means is that the president is almost always the system's prime mover, sometimes due to crisis, to be sure, but more generally because only the president combines unity, responsibility, capacity, and national election, and thus connection with all of the people. These factors put a premium on presidential leadership from the beginning, which together with, again, the open nature of the office and the growing complexity of governance in the world, to mean, as Woodrow Wilson said in his 1908 book on constitutional government, I believe it was, the president is at liberty both in law and conscience to be as big a man as he can. His capacity will set the limit. Going back to the paradox at the outset, great and controversial presidents were great and controversial because they were pushing novel constitutional visions. And this is an important theme in understanding presidential greatness, I think. We think of this, many of us think as the Supreme Court as the font of constitutional meaning, constitutional interpretation, as the locus and sometimes the exclusive locus. But in fact, presidents have been prime movers in creating constitutional meaning from the beginning of the country. These presidents were attempting to alter, the greats were attempting to alter extant or inherited understandings of the constitutional order to fundamentally change the way American governance works. Again, Washington was painting on a blank slate, but his imprimatur on the executive branch had a huge impact on it. And he made choices in accordance with his constitutional vision. Keith Whittington, in his terrific book on judicial supremacy, calls these reconstructive presidents because they sought to and did reconstruct the constitutional order. And Whittington notes that reconstructive presidents were all departmentalists who deny judicial supremacy. That's the third time I've said those terms, so it's time to define them. And I'm going to explain what those terms mean and why I think that's that what Whittington said is an accurate account of U.S. constitutional practice. So departmentalism is the view that the president is invested with independent powers of constitutional interpretation and need not defer to judicial interpretations, including the Supreme Court, when exercising the president's independent constitutional powers. Judicial supremacy is a denial of departmentalism, and it comes in many flavors. So departmentalism says the president has independent interpretive power. Judicial supremacy denies that proposition, and it comes in many flavors, but I'm just going to mention the two main ones. The narrow view of judicial supremacy is that Supreme Court judgments are binding on the executive branch in resolving individual cases and controversies. And my best understanding is that this is probably what the framers thought, and there's pretty good evidence near the founding that this is what they thought. And this is what the Supreme Court basically said in United States versus Nixon, the Nixon's tapes case, where they said there was a remarkable episode of oral argument in the Nixon tapes case when Thurgood Marshall asked Nixon's lawyer basically whether he was going to comply with the judgment of the court. And St. Clair, his attorney, hedged and hemmed and hawed, and there was much discussion about whether Nixon was going to comply with an adverse ruling in the Nixon tapes case. And the court, in its opinion, had a paragraph that talked about the importance of judicial review, and it cites Marbury versus Madison, which doesn't get you to judicial supremacy, But it ended that paragraph by announcing, I mean, it's just announcing that the court's decisions were basically binding in this case on the president. And that is the narrow view of judicial supremacy. And it's basically been the historical practice throughout our nation's history. There's some shadowy counterexamples, but I think for the most part, presidents have complied with Supreme Court judgments. FDR famously threatened not to a few times and managed to scare the court into doing some things. Ex parte Curran is the best example, but no overt defiance of a Supreme Court decision by a president. Okay, that's the narrow view. There's a broad view of judicial supremacy, which we might call the Cooper versus Aaron view, and I'll explain why in a second. This is the view that the president must follow not just Supreme Court judgments in cases in which it's a party, like U.S. versus Nixon, but much more broadly must follow the rationales and opinions in judicial decisions as binding precedent in the executive branch when the executive branch acts in other contexts. And as an example, this view of judicial supremacy, which is a view that Lincoln rejected, would have meant that Abraham Lincoln, had a duty to follow Dred Scott's holding on black citizenship in carrying out his duties of office, even though he strongly disagreed. Lincoln strongly disagreed with Dred Scott's holding that African Americans were not citizens, but strong judicial supremacy would have meant that he was bound by that in all of his other actions outside of that case. And as I'll explain in a moment, Lincoln did not view himself as bound by that decision, by that precedent in other contexts. Another way of stating the broad view of judicial supremacy is that the Supreme Court is the definitive and authoritative interpreter of the Constitution, binding on all the branches. Or as Cooper versus Aaron said, this is the case that held that Arkansas officials couldn't defy or delay the desegregation orders of Brown versus the Board of Education. The court there stated, the federal judiciary is supreme in the exposition of the law of the Constitution. Now, and they made a very strong claim that the Constitution in Cooper empowered the courts to definitively interpret the Constitution in ways that in this broader sense were binding on state officials. Now, the court has never said that, as best I can tell, and if there are counterexamples, please tell me, has never had that kind of strong departmentalism vis-a-vis the executive branch, where the relationship is much different, a co-equal branch of government. Yet the broad view, like the narrow view, is normal constitutional practice, and bear with me in explaining this. When I explain this, when I was the Assistant Attorney General in the office for the Office of Legal Counsel, trying to assess the legality of executive branch action in a variety of contexts, I treated, and my office treated, Supreme Court decisions as if they were authoritative when we were deciding legal questions. Now, we didn't do that because we had a sense that we were constitutionally compelled to do so. We had a sense that we were compelled to do so, but not constitutionally compelled to do so. This is an important distinction. To say that broad judicial supremacy has been the practice, and it hasn't been the uniform practice, is not to say that it's constitutionally compelled. And let me explain what I mean by that. First, let me say why there are three basic reasons why I think broad judicial supremacy is not a constitutional requirement, i.e., just to be clear, why the president is allowed to adopt an interpretation of the Constitution that differs from the Supreme Court's when the president is exercising his independent constitutional powers. First, at the most basic foundational or pre-legal level, it is important to remember the obvious point that Hamilton made in Federalist 78, that federal courts are subdivisions of the government. He didn't say that, that's me. And lack the powers of purse and sword, he did say that might be used to coerce compliance with government officials. The court has no tools other than its words to compel other officials to act. As Dick Fallon noted in an article on judicial supremacy, the Supreme Court is the decisive arbiter on constitutional issues if and insofar, but only if and insofar, as its decisions are ones that Congress, the President, and ultimately the bulk of the American people will accept as lying within the lawful bounds of judicial authority to render. What this means in practice is that the executive's respect of Supreme Court decisions rests ultimately on what politicians and what politicians and the people think. That is the ultimate source of the court's authority. At a second level, the level of constitutional interpretation, the reasons why strong judicial supremacy is wrong is that the president is invested with independent powers of constitutional interpretation and need not defer to judicial interpretations when exercising those powers. The judicial power is the power to decide cases and controversies, not to preempt independent executive branch interpretation outside of the case. The president's powers of interpretation flow from a whole number of his Article 1 and 2 powers, Article 2 powers plus the veto power. The Take Care Clause and the Executive Power Clause, both of which contemplate the president's law enforcement power, and both of which presuppose that before you enforce the law, you have to be able to interpret the law. The Pardon Clause and the Veto Clause have been recognized since the beginning to allow the president to bring his own constitutional interpretation to bear in deciding whether to pardon. Jefferson pardoned people that the courts convicted under the Alien and Sedition Act because he thought the act was unconstitutional. He wasn't bound by the Supreme Court any more than Jackson was when he vetoed the Second Bank, even though the Supreme Court upheld it. And the Oath Clause requires the president to swear to the best of my ability to preserve, protect, and defend the Constitution of the United States, not what the Supreme Court says about the Constitution of the United States. So here is Thomas Jefferson to Abigail Adams in 1804 basically expressing this view. You, Abigail, seem to think, they're talking about whether Jefferson had a duty to enforce the Alien and Sedition Acts and whether he had a duty, whether it was wrong for him to pardon people who were convicted under the acts. Jefferson said, you seem to think it devolved on the judges to decide on the validity of the sedition law, but nothing in the Constitution has given them a right to decide for the executive more than to the executive to decide for them. Both magistracies are equally independent in the sphere of action assigned to them. Here's Andrew Jackson in his veto message for the Second Bank. And this is a clear statement of the idea. The Congress, the executive, and the court must, each for itself, be guided by its own opinion of the Constitution. Each public officer who takes an oath to support the Constitution swears that he will support it as he understands it and not as it is understood by others. The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges, and on that point, the president is independent of both. This was Lincoln's view. This was Franklin Roosevelt's view. This was James Madison's view. This was Ronald Reagan's view, or at least his Attorney General's view. It was probably George Washington's view. He certainly had this sense that he had independent interpretive powers and he exercised them all the time. He never had an opportunity to disagree with the Supreme Court since he nominated all of them and there weren't any cases that came up that bothered him. A third way to see why departmentalism is right and strong judicial supremacy is wrong is to see, and here I'm building on something Dick Fallon has helped me to appreciate, is to see all the ways that the executive branch and the political branches more generally shape constitutional meaning through their own interpretations of the Constitution that end up influencing the supposedly independent judiciary. Presidents and Congress and presidents nominate and Senate confirms new justices. This may seem like a silly point, but the president is not bound by what the Supreme Court says. He can pick someone who has a different view of the Constitution and try to get them on the court. It's a very important exercise of departmentalism. Strong departmentalism would have ruled that out in some sense. Presidents and Congress enact laws and litigate cases that seek to get the Supreme Court to change its mind on constitutional interpretation, often successfully. If strong departmentalism is true, that wouldn't be possible. Sorry, strong judicial supremacy, thank you. If strong judicial supremacy were true, that wouldn't be possible. Presidents and Congress control federal jurisdiction. They control the number of seats on the Supreme Court. They can control when the court can meet and whether it can meet. They control appropriations. All of these powers have been wielded throughout American history by the political branches to influence court outcomes. Marbury versus Madison had the term delayed for a year and a half, not because of Marbury, but because of another case, Stewart versus Laird, which was challenging the constitutionality of what the Jeffersonians' seemingly unconstitutional eradication of some federal courts. And Congress basically said, you can't meet for 18 months. And through that mechanism and other mechanism, they were sending signals about what their constitutional view was. And without getting into the details, Marbury, in a way that's famous, and Stewart, in a way that's more overt, ducked the constitutional issue because of the influence and the threats of the political branches. Presidents have exercised the veto and pardon powers to take a different view than the court, and presidents have just ignored or pushed very hard against Supreme Court opinions in other contexts. Lincoln famously ignored Dred Scott in conferring black citizenship in the District of Columbia and in other contexts, and in passing legislation inconsistent with Dred Scott. These tools have long been wielded by the political branches to successfully influence constitutional interpretation. They help explain why the court's jurisprudence has so often been sensitive to major political concerns. They also explain why the court sometimes accommodates short-term political threats of the types I've been talking about, even as the court seeks to preserve its own legitimacy and power over the longer term. So one implication of this is constitutional meaning is not a process of detached judicial interpretation in that white building behind the Congress. It's embedded in a much larger, judicial review and constitutional interpretation is embedded in a much broader and complicated and really hard to reduce in a simple way, legal and political process. I think this process, this influence, is what legitimates judicial review and what ameliorates the counter-majoritarian difficulty. It's one of the things that justifies the court's extraordinary power to declare laws unconstitutional, to determine constitutional meaning, to resolve cases, controversial cases. The threat and reality of political control, as Charles Black once argued, are the rock on which rests the legitimacy of judicial work in a democracy. It's a way of solving Bickel's counter-majoritarian difficulty. Now, the relationship between, so lest you think I think that the president can just ignore the courts whenever he wants, and that may have been the message I've been sending so far. That has not been the practice, as I said. I think everything I've said so far about the political influence on courts and the false, the inaccuracy of judicial supremacy is true. But this relationship between political influence and the Supreme Court decision-making also explains, I think, why Supreme Court opinions and precedents are in practice almost all the time normal science, including now. Why they're followed by the executive branch, why I and OLC followed them, why the Trump administration has been following Supreme Court decisions and opinions in cases, not just judgments, but the precedents of the Supreme Court in the cases that it's lost, and it has lost some cases, in other contexts. And here I'm going to be somewhat brief, and I don't have time to fully explain this idea. As many political scientists have noted, political actors, the big question of constitutional law is, why do political actors obey the Supreme Court? What is it? Is it the court's authority? Where does the authority come from? What is the nature of the authority? How did it build it up? Political scientists have argued that the political actors acquiesce in judicial decisions because the court helps them by validating their actions across the bulk of, not all, but the bulk of cases, by resolving issues that the politicians prefer to avoid, and by offering insurance to their policies and to them once they're out of office, that things stick. The President and Congress in turn support judicial review, which empowers the court. Each side, and we've seen this throughout American history, typically incurs costs from too great or too sustained a departure from this cooperative balance. A president can suffer politically by defying a court that has the support of the people in Congress, which is why it doesn't happen very often. It takes a very special president to be actually departmentalists in a very special situation. And the court risks defiance of its rulings, potentially, or alteration of its jurisdiction, composition, and the like, those things I was mentioning, if it departs too far in the other direction. On this view, Supreme Court judgments and opinions in what we might call, what the economists might call equilibrium, are supreme. In other words, the normal state of affairs in this cooperative relationship is the executive branch treats the opinions of the court as supreme. And this, as I say, has been the normal state of affairs in American history, although, of course, it hasn't been stable always because of some of the examples I mentioned. To describe judicial supremacy in this way as a mutually beneficial arrangement among the three branches is not to degrade it. I mean, it's a very judicial supremacy in the terms that the executive branch complies with the opinions of the Supreme Court is a very powerful force in the American constitutional system, even if it's not constitutionally compelled, and even if it's ultimately very fragile. It's a very powerful force, and it always has been. All I'm trying to do is to put these arrangements, as I understand them, in their proper light. Okay, let me briefly sum up the points I've tried to make before some concluding reflections about the Trump administration. First, the paradox of great presidents being constitutionally excessive and controversial is explained by the nature of the office, which encourages and rewards energy and leadership, and which leads ambitious presidents to try to impose their constitutional visions on the country. Second, great presidents were departmentalists who used all the constitutional tools at their disposal to shape constitutional meaning in their image, including influencing the court in its interpretation of the Constitution. Third, departmentalism, at least with respect to Supreme Court opinions and precedents, is the best reading of the Constitution and of historical practice. Fourth, despite everything I've said, Supreme Court opinions and precedents are almost always treated by the executive as supreme in practice because the executive branch has an interest in doing that over the course of cases. It benefits even when it loses because it can win too, and it needs those wins, and it loses if it defies, absent really special circumstances. Now, all of this never gets discussed in Supreme Court decisions. It never gets discussed very rarely gets discussed between the Supreme Court and the executive branch. This is the way the Constitution is operated, and I've been trying to give an account for it. Lots of other people have been trying to get an account for it. But the closest the court's ever come to discussing this was the Nixon tapes case, and it just barely discussed it. Which brings me to the Trump administration. First, President Trump clearly has what I would say are ambitions of a reconstructive presidency. I think, this may seem strange, but I think the closest model to what's going on now is what happened in the first 4 years of the Roosevelt administration, Franklin Roosevelt's administration, in terms of aggressiveness against the courts, super aggressive constitutional interpretation, trying to change the nature of the executive branch and the like. And they're definitely, I don't need to recount this in great detail, the Trump administration is definitely pushing a novel constitutional vision, a very aggressive unitary executive, far beyond where the court was 9 months ago, complete control over or basically elimination of independent agencies, power to fire civil servants, robust unitary legal interpretation inside the executive branch. It's pursuing novel separation of powers ideas on appropriations and on the president's duty to enforce congressional laws. The birthright citizenship is basically an effort to rethink a longstanding constitutional principle. The president's use of force against suspected drug smugglers is yet another expansion of Article II military power. I could go on, but suffice it to say that this is a president that is trying to change the nature of the constitutional order. And he already has, clearly. I mean, I think it's far too early to tell where we're going to end up after this term, but things will not be the same. And they won't be the same in a way that's not the normal that they're not the same. They're going to be not the same in a way that's not normal at the end of a term. Will Trump ultimately succeed as a reconstructive president? Will he? I don't know. I have my doubts, but I don't know. It's not clear what to me, and this may be my own failure, what the president's constitutional vision is or where he's leading the country. It's unclear to me if the president is bringing the country to a better place or if we're in part of a downward spiral of norm-breaking and retaliatory weaponization. When I say it's unclear, I'm not shading. I really think it's unclear what's going to happen. So I make no prediction. And I will just say that those other presidents I talked about, whom at least many of us revere many of them, their presidencies were marked by near hysteria about their uses of executive power. The main thing I want to focus on is on departmentalism and judicial supremacy in this administration. Now, but President Trump and the Trump administration has been extraordinarily, maybe unprecedentedly disrespectful towards lower courts. But this is very important, unlike all of the other reconstructive presidents, the Trump administration has paid unprecedented fealty and deference to the Supreme Court of the United States. This is, in my view, not sufficiently known. This reached a peak in the important case of Trump versus Casa at the end of this term. This was the case about universal injunctions. This was actually the case about Trump's birthright citizenship order, which is contrary to a Supreme Court decision, in my view, and contrary to constitutional practice. But the actual issue in the case was whether universal injunctions were lawful or not. Injunctions that bound not just the parties to the case, but everyone beyond the case. And the background was tons of disrespect towards lower courts and tons of anxiety, I think it's fair to say, about whether the Trump administration was going to defy judicial decisions, whether it was going to defy Supreme Court decisions. Okay, so this is the context in which there was oral argument in this case, and two really remarkable things happened in this oral argument. Thing one, 5 justices openly worried and asked, to the Solicitor General Sauer, will you comply with our decisions? The question was, the scope in the case was the scope of basically lower court injunctions. But the justices were worried, and I'm not going to get into the legal details, but they were worried about whether the Trump administration was going to comply with its decisions, even though the Trump administration had been falling all over itself to say, oh, yes, we're going to, in briefs, even the President Trump had said this. So just to give you a flavor, and then that was the first extraordinary thing. And the second extraordinary thing was that the Solicitor General showed up prepared to make the most extraordinary concessions about executive branch compliance with Supreme Court decisions. To Justice Kavanaugh, he said, this court's decisions constitute controlling precedent throughout the nation. To Justice Sotomayor, he said, this is the Solicitor General, the Supreme Court would have the authority to issue binding precedent nationwide. To Justice Kagan, he said, if the Supreme Court ruled the birthright citizenship ban unconstitutional, that would be a nationwide precedent that the government would respect. Justice Barrett asked him, would he respect the opinions and judgment of the court? He said he would. She followed up, are you hedging in any way? He said, no, I am not. And then Chief Justice Roberts, in a strange exchange, he said to Chief Justice Roberts that the court can issue a decision that will bind everything else. And then finally, in the opinion itself, the Supreme Court drops this little quiet footnote at the end that said, the Solicitor General represented that the government will respect both the judgments and the opinions of this court. Now, this little exchange, which didn't get much attention, might not seem like a big deal. To me, it's a very big deal. It's a big deal because this has literally never happened before. We've never had this conversation, as best I can tell, out in public between the court and the executive branch about the extent to which the executive branch will comply with the court's opinions and judgments. Now, let me say right away, and again, I don't have time to get into the details, the Sauer statements were ambiguous. He wasn't saying, we think the Constitution compels us to comply with all of your opinions and judgments. He didn't say that. He did not say that either. He gave a variety of ambiguous formulations that made clear his pledge that the executive branch would follow the opinions and judgments of the court, whether it was because of this political equilibrium, I scratch your back, you scratch mine, whether it was just political expediency at the time, there was play in the joints. Nonetheless, it was still remarkable. Now, I said that Trump was unusual in trying to be a reconstructive president who wasn't really a strong departmentalist. That's the point. This is not departmentalism in any sense. And it's, in a way, I wouldn't say it's a negation of departmentalism, but we've never seen, to my knowledge, and I've studied this, the executive branch talking in this way to the court. Now, to be sure, President Trump has an agreeable court. It has a court that is basically on board for a lot of what he's doing. He's won most of his decisions thus far on interim orders, though I believe this is highly misleading in a number of ways. The Solicitor General has been very selective and careful in bringing certain cases to the court. There are dozens and dozens of lower court injunctions binding on the president that haven't been brought to the court. We don't know how those are going to turn out. I guess the real question is, why would Sauer pledge fealty to the court, even in the ambiguous way that I said he did? I think the answer is that the Trump administration, to some degree, needs the Supreme Court. Even though the Supreme Court is on board for much of what it's doing, it needs the Supreme Court. The Trump program is simply not going to work as well if the court rejects it, all of it. If it rejects, and the longevity of the Trump program will depend on being blessed by the court. And if Trump defied the court, which I do not believe he'll do, that would make it harder to achieve all these other gains. In short, I think that that Trump needs the court and he loses if he defies the court. They've been complying with the Supreme Court decisions. They've been paying extraordinary deference to the court, and they've been doing well so far, even though they've lost some important cases, and I think they're going to lose more important cases. So I think that the Trump administration, this unprecedentedly judiciary-defying administration, needs the court, and this shows, I think, how much power the court still has. I'm talking about practical power. At the same time, this episode shows the extraordinary fragility of the court. It was a little embarrassing to have 5 justices at oral argument saying, "Will you please comply with our decisions? Can you give us some assurance here?" Because the reality is, there's nothing other than the kind of political forces that can make the president comply. And when the court acknowledged that what the Solicitor General said about complying with the court's orders, the court didn't wrap this up in a full-blooded constitution. This is constitutionally required, and we're judicially supreme, the way they did in Cooper versus Aaron. They did it very quietly and ambiguously as a kind of just statement of what happened. So the whole episode, for me, showed that the president and the court had this mutually dependent relationship. This was a delicate dance in which neither side made strong prerogative claims toward the other, and each signaled respect for the other. And I think it just really confirms how politically embedded judicial supremacy is. Okay, let me just close by saying there are going to be some very big decisions, I believe, and it seems, coming up in the next term on presidential power. Probably this Alien Enemies Act question, which is hugely important presidential power in a 1790 statute that would give the president extraordinary power to deport largely without judicial review if the government gets its way. There's going to be at least one major removal case There's going to be the birthright citizenship case, possibly. There's going to be the National Guard, domestic military case, I think, and more. And here is a prediction. No matter what the court decides, the Trump administration, and I think the Trump administration, oh, did I leave one out? Tariffs, that's the one I left out. That's the most important one, thank you. And the tariff case, which is in many ways, in my view, the very hardest case, both legally and politically for the court. Here's a prediction. I expect the Trump administration to comply with everything the court says, both in its judgments and its opinions. And I do that, I say that not because it's constitutionally compelled, I've told you that it doesn't, because I think the Trump administration has a medium-term interest over the next 3 years in complying with court decisions. That does not mean that the court can do whatever it wants. In addition to seeking the best interpretation of the law, which I do believe the justices do, the court has to be sensitive to the impact of its decision on its authority due to political blowback. This has been a piece of reality since the beginning of the nation. How and why this process works, how the court judges in the process of trying to figure out the right legal interpretation, how to also factor in these deep political factors that can hurt the court, and how it negotiates that is a mysterious process, and there's lots of disagreement about that. Frankly, it's hard to tell. But all I can say is that's the way it's been done from the beginning, since 1801, and that's the way I think it will continue, and I think it will remain true today in this term. And I will stop there. I went on a little long. I'm sorry.
That was really great. I have a couple of questions.
Yep.
But if you don't mind, could I just start with an observation?
Please.
Since this is the Walter Berns lecture, we ought to start with President Lincoln. And as you were discussing President Lincoln's view of the court, and of course he had his famous point in his first inaugural address that on the one hand, the court's precedents or decisions are entitled to weight, but the moment we let the court decide everything in any given case, we've turned over self-government to the court. And when you look back earlier in Lincoln's career, when he's criticizing the Dred Scott case, he talks about precedent. Lincoln talks about precedent and says, the thing about precedent is it's not binding just because there's one decision. It takes repeated decisions before something settles into precedent. And Tocqueville said something very similar. And there's even parts of Madison in Federalist 37 where it seems pretty clear that these things aren't just decided by one court all at once, but there's an iteration of decisions before it really becomes a precedent.
And if I can just interject,
yeah, please.
I think that iteration of decisions, part of that is to allow these political processes to filter back in.
I think so. And my just last observation on this is, it seems now maybe we've reached a point, I mean, we reached it long ago, where we would treat a court decision as binding precedent, because in the same way that the Trump administration and presidents need the court's authority behind it, maybe all Americans on both sides of the aisle are wary of a world where nothing is really settled all at once, and we have to actually work through it over time.
Yep.
I have a question about presidents, then a question about justices,
Okay.
and then we'll open it up to the floor. First question about presidents. Almost 50 years ago, when President Carter was having so much trouble in office, a lot of his advocates said the problem was the presidency. The presidency had become too big for one person. And then by the end of the Reagan administration, you had the American Enterprise Institute publishing a book on the fettered presidency. You had the Heritage Foundation, was it, that did the book on the Imperial Congress? Those books aren't written anymore. That was only 40, 50 years ago. What's changed in that time that it seems laughable now to think about the presidency being too big for one person, or the presidency being fettered, or Congress being imperial? That was just 40 years ago.
Yeah, that's a great question. I'm not sure I have a great answer. So first of all, it's not clear still. I mean, there's some people who believe that the presidency still doesn't have adequate power, and that there's a lot more room to go to give the presidency complete. I mean, the Trump administration is at the very beginning of, in my view, of imposing absolute control over the executive branch. They have an absolutist view of the unitary executive, and there's a very powerful argument behind it. and it raises lots of, and this is about basically, being really simplistic, the president, the sprawling bureaucracy that is so, an administrative state that's so consequential in our government, and is politically unaccountable, and that the president can't control it. This is a complaint that Franklin Roosevelt made. It's a complaint presidents have made forever. Anyway, they still don't have an absolute grip on the executive branch. There's a lot more room to go. That's the first point. Second point, obviously, I mean, so many things have changed. One thing is that Congress has gotten out of the game altogether. This is a truism. The Supreme Court in the last 30 years has been enhancing vertical presidential power on a number of fronts, enhancing the unitary executive. So presidents, and it's not just Republican presidents. Democratic presidents, Obama and Clinton, were big-time Unitarians, even though they didn't like to use that word. They liked centralized power in the White House. They liked to have a powerful directive power. Elena Kagan, of all people, wrote a very famous article glorifying the Clinton administration's very aggressive directive power. So there's been a movement, that, a bipartisan movement, supported by the court in this direction, I think is the basic answer. By the way, I think these things go in cycles. Because the basic trade-off is, to my mind, there's a huge danger in an unfettered unitary executive. And that is basically that if there's too much control, the president can use the unitary executive for corrupt ends. And so that's the one extreme case. The other extreme case is you've got this out-of-control bureaucracy / deep state that is doing things not in the name necessarily of Congress or the president. The president has these responsibilities but doesn't have the power. And that tension is not new. I mean, I'm not an expert in this, you are, but it's been going on at least since the New Deal. And we're just in a pendulum swing in one very powerful direction right now, I think. Do you agree with that? Which part do you disagree with?
I would like to think it's a pendulum swing, but the pendulum just keeps moving in one direction lately.
Well, that's what pendulums do. They move in one direction until they reach a certain height.
One hopes. One hopes. I am struck by how there is, among agency personnel and among advocates for agency personnel, the sense that agencies have a mission and they're dedicated to the mission, but it's not necessarily the mission of the president or the mission of Congress and the laws. The public administration community, the academics and the public servants, they have this entire vocabulary for agency mission that's so detached from either the exact words of a statute or the intentions of a given president that I think actually there's a lot more to be done to push back against that. And even if one doesn't like the way President Trump is pushing back against it, and as you know, I have a lot of qualms with that, I think this is going to take a lot more than one fight to
I agree. That's why I said there's a lot more room to go. I agree with that.
Let me ask you about judges and justices. A few years ago, Justice Kavanaugh, then Judge Kavanaugh, gave the Walter Berns lecture. It's here in the book, and it's well worth reading. It's on the judicial statesmanship of Chief Justice Rehnquist. And statesmanship is easy to understand in the presidency, harder to understand in the courts. When Madison wrote that ambition would counteract ambition, we think about it in terms of the president and Congress, and it's kind of easy to imagine their ambitions clashing. But most of those clashes now seem to be the president's ambition against the courts. In studying these fights between the courts and presidents over the decades and decades, do you have a sense of what judicial ambition ought to look like?
I don't have a fully developed view of what judicial ambition should look like. I don't. Judges are maximizing at least two things at once. They each have their views of the law. I don't think the judges are excessively political creatures. I do think that they act in good faith to try to interpret the law in most cases, and they're pursuing those goals. But and I think that they're trying to maximize ultimately their vision of law. But remember, these are multi-member institutions. They have to get along and compromise and come together on certain things. And then there are the political realities, which I tried to emphasize, that are often below the surface, sometimes on the surface. But the court it's never been oblivious to these things, ever. And so they have to take that into account also. And so, and I was alluding to this at the end, and I ran out of time to explain it, but how the ideal mixture of that is a question of wisdom, I think. How to vindicate the proper constitutional vision in a way that is going to work in political reality.
Maybe sticking with Justice Kavanaugh for one more question, and then we'll open it up. In the last few months, Justice Kavanaugh has said some interesting things and written some interesting things about the way the court goes about its work. And and this is in his opinion in the nationwide injunctions case. The basic challenge that the Supreme Court faces in trying to manage the lower courts in fast-moving litigation involving the executive branch. And Justice Kavanaugh seems to be the one thinking the most about this, about how the court might have to update the way it goes about its work. Just to remind you, you and I served on a commission once upon a time about reforming the court.
You served longer than I did.
I served about a month longer than you did. It was President Biden's commission on the Supreme Court. Its fans referred to it as the Court Packing Commission. Its detractors referred to it as the Court Packing Commission. But in thinking about these both historical and now current fights around executive power in the courts, do you have a sense of any good reform to the judiciary that might better position it to do its substantive job effectively in a way that wins the people's confidence?
Gosh, you're asking me questions I don't have answers to. I'm embarrassed.
No, not at all.
The problem, it's clear that the issues that you're referring to, Justice Kavanaugh, talking about the emergency orders or interim orders docket, the shadow docket, it's clear that there's been a major institutional change on the court in the last decade, such that in large part because of presidential aggressiveness, in large part because of universal injunctions, now they've been diminished, but this problem's not going away, where the court is pressured to act earlier and earlier to decide cases with a limited record, limited briefing, usually no oral argument, and often not much explanation. And this is one of the things that Justice Kavanaugh was talking about in these opinions. I don't think this is sustainable for the court. They're deciding too many important legal issues with not enough explanation. And I think they need, and they've been groping towards better answers. They need to come up with, there are genuine pressures that are requiring them to decide earlier, but they need to come up with alternate mechanism between full-blown merits argument that takes 6 months and all that briefing and a decision in 2 weeks that is an order that announces the outcome with no opinion. And there are, you can have what they did in CASA, oral argument early. You can have certiorari before judgment. You can have more amicus briefs come in early. And they've been trying to update, but they clearly haven't figured this out yet. And I think this is the major challenge. It's taking up, the SG's office is restructured because of this. The Supreme Court, the way it operates, best I can tell from talking to people, has changed because of this. But they haven't figured out a method that combines what needs to be done in interim orders because of these new pressures with a way to make their decisions more convincingly judicial.
This is a place, I'll just add, where the expectations of the American people are so difficult to grapple with. I mean, at risk of trivializing it, we live in an era where we get upset if our Netflix buffers for 5 seconds or if our Grubhub is 10 minutes late. And we want our policies made today, and we want the litigation tomorrow, and we want the Supreme Court to decide it the next day. And I don't know how the court.
Well, the court wants to decide it the next day. That's the problem. I mean, it's a serious challenge, and they have not figured it out yet.
Speaking of keeping the American people waiting, there's a lot of smart people in the room who could ask better questions than these. So maybe we'll open it up. We have a few minutes left. There are some microphones. So if you have a question, please raise your hand, and I'll try to find you behind the spotlight. I see one question here, the first one, and then I see you, sir. You'll have the next question. It's right there. And please introduce yourself. This is all being live streamed.
Peter Keisler.
Hi, Peter.
Great talk, Jack. Thanks. That was terrific. So when you talk about departmentalism and each branch has power or obligation to decide for itself what its best view of the law is, that kind of conjures up this picture of each branch kind of earnestly trying to figure out what is the best reading of the law. I want to follow that. And one could imagine another view of what a president is doing, which is saying, I want to advance my policy program as far as I can, and there'll be limits on that, and those will be external limits, and whatever I can get away with, I'd like to get away with. And I don't think that possibility changes any of the completely valid points you've made about what our constitutional structure is and what it comprehends. But I'd just be interested, how many of the great presidents that you described as great, you know, and look, I recognize that a president is not individually making these determinations.
Some of them were, though, yeah.
Sometimes, but you have lawyers in the executive
Yeah.
branch, and you either have a president who wants his lawyers to be earnestly trying to tell him what the best reading of the law is, and ones who don't. So, like, how many of these great presidents were motivated by a desire to find the best answer in the law and obey it, and how many are just plowing ahead and what can I get away with?
Great. So I'm glad you mentioned this, because this is the point I was going to make about the Trump administration that I just didn't have time, that might distinguish it from these other presidents. So Lincoln clearly thought about these issues deeply. He took them seriously. Roosevelt, believe it or not, did take them, in my judgment, and I studied this. He was a lawyer. He had a C average in law school, and he had this is going to seem like it's indulging your hypothetical or where you're coming from. He had a political view of the Constitution. And I think this is important to understand, that this is a legitimate way for presidents to look at the Constitution, by which I mean he didn't think about constitutional interpretation the way judges do. He thought about it the way presidents do, which is, it's hard to articulate. He had a larger vision of where the country should be. He thought that the Constitution was a political document, as he put it. I mean, he said it's not just a lawyer's document. He wasn't the only person who made that. A lot of famous statesmen in American history made that. And so I would say that Roosevelt was a serious constitutionalist, believe it or not. And he had red lines and things he wouldn't do, and he didn't do because he thought the law wouldn't permit him to do it. And he understood, but he was skeptical of lawyers. Robert Jackson, in his book about FDR, was skeptical of pointy-headed lawyers because he thought they were too pointy-headed and getting in the way, kind of what you're talking about. But I don't think it delegitimates it. So I would put FDR in that category. I would put Lincoln, definitely Jefferson, Jackson less so. Washington, not at all, because he wasn't a lawyer, but everything he did, he had full-blown cabinet debate with lawyers named Hamilton and Jefferson, among others. And so I would say most of them took what I think, Jackson is the example I don't know well enough, and I doubt he did, although he had a certain vision. I would say they took their legal obligations seriously within the context of the presidency, which is not the same way as courts look at it, and I think that's legitimate and part of departmentalism. And I don't think it just reduces to, I just want to do whatever I want and interpret the Constitution whichever way I want. That's what I believe, and I'm not convinced that any of this is going on in the Trump administration.
Well, the microphone is finding the next
Does that
gentleman
answer your
here.
question?
You mentioned Washington. I just wanted to point out, Jack, it is interesting that in Washington's first term, I believe it was his first term, his instinct in one of the crucial constitutional debates that came before, maybe the Neutrality Proclamation, was to try to seek out the Supreme Court's advice in advance.
Yeah.
And of course, the court said, no, we don't do advisory opinions, which was nice. It gave Sarah Isgur a name for her podcast. But one wonders, of course the court had reasons for not doing that. They wanted specific cases and controversies.
Right.
Of course, delaying the court's involvement until after the policy has been finalized and is in execution changes the political terrain completely.
Yeah.
And one wonders what that alternate history would have been like if the Supreme Court had an institutional role at the front end.
I don't think it would have been good for the court.
Yeah.
And I think they were wise to reject it. And by the way, they asked the justices those questions after. It was kind of ridiculous because the great lawyers in the Washington administration had these amazing deliberation with these memos back and forth between Hamilton and Jefferson, and they kind of ended up with the conclusion, it was a complicated constitutional analysis, that we can issue the Neutrality Proclamation. So they knew that they could do this, and they had great lawyers. They were trying to slough off responsibility. Yeah. They were there were some hard questions that they didn't want. It's going to be easier for us if the court answers these questions. And that's one of the reasons I think that the court said no.
I've asked too many questions. There's one left here, and really briefly, because we're over time. If you don't
Okay,
mind.
very briefly.
sir.
You indicated that there's nothing to compel a president to comply with a Supreme Court decision, but isn't Congress there that could possibly compel or oust a president? Like specifically, when Nixon said he would comply with the tapes decision, he knew that he was already on the verge of impeachment. He knew if he didn't, he was likely going to be ousted because of it.
Great question.
Yeah, but if I wasn't clear, I said there's nothing to compel the president other than the people and the politicians. I mean, it's politics that can compel the president, and so I'm agreeing with you. But are those politics present in any particular moment? They were very present in the Nixon tapes case. So even though Nixon's lawyer suggested they weren't going to comply with the decision, I think it was an hour after the decision came down, Nixon announced he would comply because the politics just collapsed on him. So I definitely think that's an important factor in ensuring practical judicial supremacy, yes.
Jack, I hope you didn't feel too much pressure knowing that tonight's speech will someday be the first speech in volume 2
I hadn't thought about
of
that.
this. Before we break, I just want to say again, please pick up a copy here. Just want to thank our colleague Gary Schmidt for such
Yes,
a,
I do
know
too.
speak
Thank
on
you,
behalf of
Gary.
all of us. What a wonderful, wonderful volume this is to have them all in one place. And of course, we want to thank Mrs. Berns and Walter's family for joining us tonight. Very grateful all of you could join us tonight, but above all, please join me in thanking Jack Goldsmith.
Thank you very much.
That was great.